Right, well, Mr. Atkinson, now we proceed.
I, rory-brian, am here to recall a factual sentence in a constitutional court record. I have with me my grand jury of my peers who have travelled from the four corners of the territory of éiRe, Ulster, Munster, Leinster and Connacht to witness a constitutional court record which you have acknowledged. We were here doing business. You have recognised the sovereign seal. Is that correct? Is that true? Do you recognise the sovereign seal over your head?
Yes. Now, Mr. Mahoney, on
Do
the
you
last...
recognise
Excuse me,
this
Mr.
constitution?
Mr.
Do you recognise
no, I don't.
this constitution?
That
For the
was...
final time, it's Irish constitution. I'm going to rock that. Do you recognise Irish law?
I recognise Irish.
What do you mean not? We're here now standing in an Irish court in the territory of éiRe. I have with me Geneva Bible, Irish Constitution, the rule of law in the territory of éiRe. National identity.
Ladies and gentlemen, you may sit down.
Men and women, please sit. Thank you. I have with me 40 pieces of silver and not. Honest facts, no more nonsense. We're going to respect law, as men and women, stand in the image of God on God. I'm here with a special divine appearance to pay any debt that is true and due. I am present in this arena, in the territory here, as a national and a native, living, indigenous man, protected by the divine Christ God. Under Irish law, on one rock. Do you understand? Do you understand?
I hear what you're saying.
Do you understand on one rock?
I hear what you're saying.
Maybe before Judge Ivory application this matter, taking this apart for a hearing, Judge, it was in the 6th of May, on the 6th of May being service stood, and you went through all of the updates and service stood. On that occasion, Mr. Adamson alleged that he dealt with dirt.
I object. We've just acknowledged that an Irish national, living man, is standing in a Constitutional Court of record. Who is this man standing to my left? Where is he deriving his authority from? Is it true?
Would you like me to answer that
Yes.
question, Mr. Atkinson?
I, rory-brian,
Would you like me to...
we have no more nonsense play acted in a Constitutional Court of record. If you wish to address me, you will use my Christian name that my late mother gave to me, rory-brian.
rory-brian. Rory-brian and Mr. Mahoney is a barrister. He's representing Pepper Finance, who brought a case against you, which you were here to defend. Yes, Mr.
I'm not here to defend. I'm here.
Well,
Right, so you say he's a barrister. Okay. So is he an agent for the said? Or is he a witness?
no,
Okay, he's an agent.
he's here to
Can the man speak
Mr. Mahoney, you're
as the man
You're
to address all
Be
your
quiet,
time?
please, and don't interrupt me when I speak.
I'm instructed on behalf of the plaintiff to appear on behalf of the plaintiff, Judge, as I did on the last
Now,
occasion.
continue, Mr. Mahoney. Sit down. Sit down, rory-brian, please. Sit down, please. Sit down.
Are we going to continue within the Constitutional Court of record? Ignorance of law is no excuse. maximum
I
law.
don't know what you're talking about. Please sit down. You are disrupting this court now. Please sit down. As a
Ignorance
judge
of law
of
is
the
no
court.
excuse. Maximum law. Ignorance of law is no excuse.
There's no one here anymore.
Maximum law.
Yes.
Third and final point.
Yes, very good. Sit down. Sit down, please. Sit down, please.
Now I'm going to rest.
Sit
For a
down,
moment.
please. Sit down, please. Mr. Manley.
On the 6th of May, Judge rory-brian made 3 allegations to the court. Firstly, that he constructed a third or engaged in service of an authorised third party, that he been defrauded out of the sum of €35,000, and that fraud is currently under investigation by the RD. Secondly, he made an allegation or submission, Judge, that the court fell under the Family Home Act 1976.
I object.
You cannot.
We are here in
Sit down,
Constitutional Court of Record. Article 41 on Bunrocta protects the family. The family was the foundation of the state, was founded on
We're
the
not
family.
arguing against that.
Well then, can we have no more nonsense in relation
Sit
to...
down.
Thank you.
No family home declaration had been signed at that point, Judge. You adjourned the matter to the 15th of June to allow rory-brian to file an affidavit setting out this information. First, the plaintiff had heard of that information was on the 15th of June. I thought it was on the 6th of May, Judge, the first time it was for you. We were then back here on the 15th of June, Judge. No affidavit had been filed before that.
Objection.
I was handed a bundle of papers by rory-brian on the morning of Judge, and respectfully, that affidavit did not deal with any of the issues that the court directed it to deal with.
I object. The court did not give directions of my court. You have received a conditional acceptance through the UCC postal rule. You have also received, and you are required under law.
We're not dealing with an acceptance. We're not dealing
Listen,
with an acceptance.
In there's affidavit. You have now affidavit directing from me. You are required under law to respond.
You then, on the 15th of June, Judge, made a very clear direction. You adjourned it to today's date, and you instructed rory-brian to file an affidavit in this court setting out the allegations that he had made on the 6th of May. Informed him how to do that, that it hasn't filed in the court, it doesn't have to be served on the plaintiff also, Judge, and to today that hasn't been done, Judge.
Tell me this, Mr. Manley, I've heard all the things.
You have already on the 6th of May.
What's your application?
I am seeking to proceed with an order for possession, Judge, of the property, and I think under all the circumstances, Judge, it may be best if I take the court through the affidavit of Jeffrey Johnson in full, perhaps, Judge, for the sake of clarity.
I, rory-brian, object to all the nonsense and disrespect within the territory of éiRe, the Constitutional Court of Record.
In time, not now. Just sit down.
I will take my opportunity to speak within my court. And I did respect a direction, not an order. And we have filed under law. Here you go. I know you've seen it. Would you like me to read it out to you?
Mr. Bryan?
Here we go, rory-brian.
Rory-brian, sit down, please. You will get an opportunity to read out anything you want when Mr. O'Malley is finished. You
I will
will sit
speak.
down.
Affidavit of rory-brian. Ground and affidavit
I have no problem.
of rory-brian. Care of St. Michael's, Howsham, Borley, Wexford.
Mr. O'Malley,
Whose occupation is stated as a gentleman.
you have to listen for a second. Mr. O'Malley said he hasn't got a copy.
Well, I would suggest he has to look at who is he representing, who is he representing
Just a
today.
second.
Who is he representing today too? He has received it, it's here in the court.
Just there was one of the papers that was handed in the 15th of June.
No, I object.
When was this date? When was this handed in? No, just a second.
No, it is here, I just want to show proof.
When was it handed in?
It was registered post through the UCC rule to here, to yourself, directed through your posted, to the company, to the company you're here
Notice what you just tell me.
speaking for. You have all received my document. You have acknowledged in court that you've seen my document. Is that true?
No, I have to not.
Did you see in the last court we were here, you acknowledged my documents? Did you see my documents?
None of the
My
documents.
conditional acceptance.
Would you like me to answer?
Can you answer the question, is it true you received my
Would you like
documents?
me to answer?
Is it true?
Would you like me to answer?
Is it true?
Would you like me to answer? I received documents, but I haven't received an affidavit which set out how you say that the property is a family home.
Well, you've recognised on one rock there.
Oh, would you get to the point?
Have you recognised the Constitution?
The Irish Constitution, yes.
Go Gaelic, Irish law,
1936.
original 63 article. Original, no I'm not. No I'm not. I have here with me today, there's the draft Constitution. It's that I am relying on. This is Irish law, éiRe. Are we in the territory of éiRe?
Yes.
But please do not, we are here now, we are standing on land.
Can I see the papers
You certainly
you're
can.
referring to? And first, the
According to
affidavit, that's all I want to see is the affidavit. Not that you are not.
Now, okay, are you a member of an Irish economy? Okay. Within this draft Constitution of Irish law, 1922 Constitution
I'm right.
was repealed.
All right.
Case dismissed, she's a ship. She's a bowel ship.
Thank you. Written report.
What does that mean?
Case is dismissed.
So what does it mean?
She left the ship. He's got the highest authority in the court now.
Silent sheet.
Sorry.
All right, please.
This report is, I'm looking for the affidavit and nothing else. I don't want anything else.
I have enough of you to respect law. On the territory.
Thank
No,
you very much.
excuse me, you also wanted to see the draft
I
Constitution.
don't want to see
Yes,
that.
you did.
No,
Yes, you did.
I act under the 1937
It's
Constitution.
here in my hand.
1937.
1937 on one rock there. It's here in my hand.
Show it to Mr. O'Mahony there, will you?
So too, draft Constitution.
It's not a draft, there's a full
Okay,
constitution.
full Constitution. Enacted and given to ourselves and evoked. Constitution of Irish law. Do you understand Irish law? Pardon me, Mom. Now we have no more nonsense. We will respect the courts. We're all Irish men, nationals here in the territory of éiRe.
Right,
And we stand here in the rule of law. Now I'm going to ask some questions because he has acknowledged.
I am going to open the affidavit that you have sworn, which says, grounding affidavit of Rory-Brian, care of St. Michael's, Paul Shone, Goring, Wexford, whose occupation is stated as a gentleman of age 18 years and upwards, who makes oath and says as follows. 1. This affidavit is made from facts within the knowledge of the above-mentioned Rory-Brian, hereinafter referred to as I, or the deponent, save where otherwise appears, and where so appearing, same is believed to be true. 2. I refer to the pleadings and proceedings and pleadings already had in here to date when produced. 3. Let the following be known as the sworn affidavit by I, Rory-Brian, written in response to the direction of the presiding referee stroke judge out of the Doyle family, pursuant to proceedings 497 stroke 2017. 4. I, Rory-Brian, rely on the highest law of this nation, which is the Irish Constitution. Further, the deponent says and fully understands that the Constitution to be the full canopy under which the justice is administered and legal rights are enforced in the courts. Pursuant to Article 34, by its express provisions, the Constitution recognises and guarantees the protection of the deponent's fundamental rights. I, rory-brian, also say that Article 34(1) expressly states that justice shall be administered in public courts established by law by judges appointed in the manner provided by this Constitution. Furthermore, the opponent understands that the Irish judiciary, under the terms of the said article, will be free and independent as regards the operation of their judicial function, with no restrictions except this Constitution and the law. The state and all organs of the state have a lawful obligation to guarantee the deponent's lawful enforceable rights. The deponent says further that he is entitled to assume that the judges in any court are constitutionally bound in this regard and obliged to uphold those rights on the basis of such personal and professional independence as regards their oath. This affidavit is authorised and signed by the deponent, refers to the lawful paperwork already before the court, hereinafter referred to as exhibits conditional acceptance, and all parties concerned. While presentation of same paperwork has already been acknowledged by Judge Alice of the Royal Family, by her own admission she is not yet read. Consequently, the deponent suggests that indeed all parties going forward to take full cognizance of the lawful facts and evidence before the court as referred to in this affidavit and exhibited in conditional acceptance. Till such time as all parties have paid due diligence to the said lawful facts, it could be deemed prejudicial for those related proceedings to progress, which would be in direct contravention of the constitutional protection right of the deponent, pursuant particularly to the provisions as set out in 34(1) and 43 of the Irish Constitution. Known also that this affidavit is filed pursuant to Article 8 of the aforementioned handbook for month. It is neither signed nor sworn.
It is signed and sworn that has been received. If you wish me to sign here today, be the witness that we're here in the jurisdiction under law. I will, in front of my witnesses, give my signature as
rory-brian, I have read the affidavit and I'm about to hear from Mr. O'Mahony in relation to an affidavit. Thank you.
May it please the court, Judge, I take you to page 9 of the booklet of speaking to us.
Sorry, I object. We cannot move from the rule of law of a living man into personage with no facts. We are here, you heard the word poetry.
I've already heard the facts.
We cannot leave the facts.
I have heard.
As a judge within said constitution, you are under oath here today.
I've heard the facts.
I'll have no more nonsense.
rory-brian, I've heard the facts. I heard them. I mean, this is your third time in court. Right, go ahead. What page are you
Page
referring
9 of the booklet.
I object to the public cannot be, plastic, water cannot be brought into land.
That's rubbish now.
Okay, I'm going to ask him, I just want to speak now, okay? We need to speak.
No, you're not.
Now with this man, no. You?
Mr. O'Mahony's turn. I just let you out.
Okay, when you finish with your nonsense, I will then be ready to continue with the facts. Are you stepping outside of the law to continue here today?
No, he is not, because I wouldn't permit it.
So, are you permitting
Participate, sir.
non-factual documents to be brought in to a constitutional court of record?
I I'm permitting affidavits which are sworn, one which was submitted by you was on sworn. I'm permitting Mr. O'Mahony to open his affidavit.
Within what jurisdiction?
Within the jurisdiction conferred on me by my appointment.
Under Irish law.
Under Irish law.
Are we correct in that? Okay. So is this Irish law he's going to use to you today? Under hearing. There's no acting, playing, messing. We're constitutionally bound. We're constitutionally bound. Do you have constitutional bound articles to produce to the court today?
This is statute law.
We're not. No. How dare we? People of éiRe. How shameful do I feel right now?
Which is under the Constitution. Which is under the Constitution.
We are here in law, the rule of law. Now, I'm going to continue with the question because I must ask, and I will. And in law, all states and men will be referred. Will be referred. Okay? To the law. Equally. Okay? Under law. Not statute. Law. Okay? You understand this? Who can administrate property without right? Ask you once again. Who can administrate property without right? For the final time, I'm going to ask. Silence. Acquiescence. Who can administrate property without right?
This court can administrate property according to the law of the land.
Is it true this court can administrate property without right?
This court can administrate property.
Is it true this court can administrate property without right? In front of the witnesses here today, is it true
Then my answer to that.
this court can administrate property without right?
My answer to that question.
Yes or no?
This court, if you want to listen.
I want to hear a yes or no. Is it true?
I'm not giving you
You're not giving me this.
this court.
In a court of law, you are refusing me my right of an answer of truth.
This court.
Sorry, I object. If you're not giving me my rights, I can't listen to and take
This
my
court
rights.
can administrate property in accordance with the law of the land and in accordance with the Constitution.
Produce the obligation, the contract, upon which you or anyone else within this arena is relying upon, which gives jurisdiction over rory-brian's property immediately, post haste, without delay, today.
You have it there, the papers in front of you, submitted by Federal Finance, which exhibit the
This-
contract.
Has no facts. Characteristics of wordings is foreign language, ASL, American Sign Language, it's Roman civil procedure. I'm going to move on because this is very important for people, indigenous, native people, born into that territory of éiRe. Do the rules of Roman civil procedure apply to all? Rory-Brian, Irish national, native in the territory éiRe, who is present here today.
Laws that apply to you, to me, and every person in this state.
Answer the question.
I am answering it. It are derived from the Irish Constitution and statute.
Well then, that clarifies. This has no jurisdiction or fact.
I disagree.
I'm going to ask you one more time to answer the question. Do the rules of Roman civil procedure apply to I, Rory-Brian, Irish national, native in the territory of the sovereign seal over your head, éiRe, who is present here today. Do the rules of Roman civil procedure apply to all?
The only one.
Do the rules of Roman civil procedure apply to all?
The only rules that apply in this court are the Constitution, statutes of the state, and they apply to every single person in this.
Okay, I'd like to raise this key in my hand here. There is no constitutional fact within this. Is that true?
There are contracts made pursuant to statutes which are pursuant to the Constitution.
Do the rules of Roman civil procedure
They pass
apply to all? I haven't got an answer yet.
Yes, you can.
I want an answer to this in law. Do the rules of Roman civil procedure apply to all? rory-brian, Irish national, native in the territory of éiRe.
If they are in accordance with the Constitution of Ireland and the Statute of Ireland,
Roman civil procedure is not in accordance
then they don't.
with the Irish law, but then they don't apply. Go on, me and one of us. No more nonsense inside a court of law.
And I remind the people in this court, this is the solemn court of Ireland, and you will not applaud
éiRe.
again.
Yeah.
Thank you. Thank you. Now we have no more. We've established the facts. Does any man or woman under God want to step outside facts again and commit treason against Irish men and women within this court here today? Ignorance of law, no excuse. Maximum law. Ignorance of law, no excuse. Maximum law. Third and final time. Ignorance of law, no excuse. Maximum law. I'm here. We have established the fact. Please address me. That's all we've done.
I have been doing. Now, can you now allow your affidavit has been read out? Can you now permit the other side to say something?
We want a full, honest response. Hold up on one. Honest.
Just we take updated there, paragraph 1, updated Jeffrey Johnson, Director.
I object. I want a response to my affidavit. I have just clarified with you, sir.
Judge,
Ma'am,
I don't see how we're going
I
to
just
proceed.
clarified here, Judge, excuse me.
The only option.
I object. I object. We just clarified. Roman civil procedure. Is not English, okay? We just clarified.
Overstepping, you are disrupting this court.
I'll move on. I'll
Do
move
not
on.
desist. I will find you in contempt. It is something I do not want to do,
Okay.
but you are now bullying and taking over the
Okay.
court.
All right.
Sit down.
This is my court.
I said sit down.
I'm going to say this one more time, just to remind you of something.
No, I'm going to tell
I'm going to remind you, you
sit down.
said he needs to respond to my affidavit. No more nonsense.
I have just...
My affidavit responds.
I'm going to
Thank
find
you.
you in contempt of those behaviors. Now,
My
so
affidavit.
Nancy, you have served this on rory-brian.
Yes, Judge, again,
Liberal, go
updated.
ahead.
I object.
No, sit down, please.
What happened? You served on rory-brian. Have we evidence in the court here today of something served on rory-brian? Where? Okay.
I've gone through the affidavits of service on the last
We just
page.
have seen on heard in witness in the court. And more than sin. And that's sin as well. I want you, the man, point out.
Mr. Rory.
No, you need to
Rory,
finish it.
Brian,
Very important.
just 1 minute. I'm writing, and will you compose yourself? You are not taking over this court, and that is it.
This is my
right.
court. You will come back here. You are committing treason in a court of law.
Yes.
Now, we're still here. We're still here. We need to finish this. Eugene, you are now sitting in front of me. Is that correct? As a living Irish Mason man. Under this court here today. Eugene, are you here in the court?
3 times. She leave the court 3 times. The case is not dismissed. 3 times.
Eugene,
She can't.
Eugene,
She can't. Because the rules and statutes doesn't apply to
And
living
you're
on.
going to open your affidavit, and you're going to
You will
ignore
have to
any of
consent to
it.
it.
Because I've had too much of this at the moment, because there is nothing sensible about it. Go.
I'm Jeffrey Johnson, Director of Shoreline Residential Designated Activity Company. I'm its registered office, 6th floor, living floor, Easton Close, Dublin 2, aged 18 years and upwards, make oath and say as follows. I say that I'm the director of the above named plaintiff, and I say that I make this affidavit for and on behalf of and with the express authority of the plaintiff herein. I further say that I make this affidavit for the purpose of the plaintiff's books and records of accounts in relation to the events indenture of mortgage in charge, the subject to these proceedings. I further say that I make this affidavit for facts of my own knowledge, save as where otherwise appears, and where so appearing as needed safety true and accurate. Paragraph 2. By virtue of transfer order made in the High Court on the 1st of July 2011, pursuant to Section 34 of the Credit Institutions Act 2010, the assets and liabilities, other than certain exclusions, of an Irish Nationwide Building Society, hereinafter called the Society, were transferred to Anglo-Irish Corporation Limited. By special resolution dated 3rd of October 2011, Anglo-Irish Bank Corporation Limited changed its name to Irish Bank Resolution Corporation Limited. Paragraph 4. Pursuant to the Irish Bank Resolution Corporation Act 2013, the Minister of Finance made the Irish Bank Resolution Corporation Act 2013, Order 2013 on 7th February 2013, providing the orderly winding up of Irish Bank Resolution Corporation Limited, and Eamon, Richardson and Kieran Wallace were appointed joint special liquidators. Paragraph 5. Pursuant to the deed of transfer dated 6th of June 2014, entered into by Irish Bank Resolution Corporation Limited, acting by one or both of the special liquidators as agents and without personal liability, all rights, title, interest, benefits, liabilities, duties, obligations of Irish Bank Resolution Corporation Limited in and to the mortgage and the premises transferred to the plaintiff. I beg to refer to said transfer order made on the 1st of July 2011, the said special resolution dated 14th of October 2011, and said deed of transfer dated 6th of June 2014, and that's the exhibit A of your booklet does.
Yes.
Paragraph 6. Pursuant to the Companies Act 2014 and by ordinary resolution, Shoreline Residential Limited, private company limited by shares in Virgin Energy Designated Activity Company, Shoreline Residential Designated Activity Company, number 53942 on 22nd August 2016. In the circumstance, the plaintiff is entitled to the interest of the mortgagee under the presentation of mortgage and charge, and that's exhibit B. Paragraph 7. I would advise and leave that, pursuant to section 6312 of the Companies Act 2014, the re-registration of Shoreline Residential Limited does not affect any rights or obligations of either Shoreline Residential Limited or Shoreline Residential Designated Activity Company, or render it effective on legal proceedings by or against Shoreline Residential Limited or Shoreline Residential Designated Activity Company. Furthermore, any legal proceedings which might have been continued by or commenced against Shoreline Residential Limited in its former status may be continued by or commenced against it in its new status as Shoreline Residential Designated Activity Company. And under the credit servicing arrangements judged at paragraph 8, I say that the plaintiff appointed Pepper Finance Corporation Ireland Designated Activity Company, formerly Pepper Finance Corporation Ireland Limited, hereinafter called the Servicer, to undertake certain credit servicing activities on its behalf. The defendant was notified of this appointment by letter dated the 10th of June 2014, and I beg to refer to a copy of this letter sent from the plaintiff to the defendant, upon which marked the letter C I have signed my name prior to swearing job. In this affidavit, unless it is expressly stated otherwise, references to communications from the plaintiff to the defendant include communications from the plaintiff directly and from the servicer acting on behalf of the plaintiff. Paragraph 9. I say that prior to the age of 2015, the plaintiff, while not regulated entity subject to 2013 Code of Conduct on mortgage arrears, chose to voluntarily apply a framework to correspond to the CCMA 2013 framework insofar as reasonably practicable. I say that the Consumer Protection Regulation of Credit Servicing Firms Act 2015 came into force on the 8th of July 2015, and the Credit Servicing Act, which amongst other things amended the Central Bank Act 1997. The plaintiff does not undertake credit servicing within the meaning of Section 28 of the Central Bank Act 1997. I say that since the coming into force of the Credit Servicing Act, the plaintiff has complied with its obligations under Section 34G of the Central Bank Act 1997. In particular, I say that the plaintiff has not instructed the servicer to take or fail to take an action if the taking or failure to take the action would otherwise be prescribed consequences within the meaning of Section 33AN of the Central Bank Act 1942 if a retail credit firm took or failed to take that action. And under verification of factual matters in civil bills by paragraph 12, I beg to refer to civil proceedings issued herein. I say that such statements therein as relate to the acts and deeds of the plaintiff are true and correct, and such of the statements therein as relate to the acts and deeds of any other person or persons likely to be true. Details of premises judged in paragraph 13. I say that particulars of the premises are set out in the schedule of the civil bill of possession herein. Paragraph 14. I say that the full address of the premises is Pool Shown, Court Town, Corey, County Wexford, and that the premises are made up of lands and a dwelling house, and that the premises are contained within folio number WX6289F in the County Wexford. The defendant was registered as full owner of the premises on folio WX6289F on the 13th of June 2005, and that's exhibited at paragraph D of the affidavit. Paragraph 15. I say that the market value of the said property does not exceed the sum of €3 million. Paragraph 16. I say that the premises is not family home within the meaning of Section 2 of the Family Home Protection Act 1976. Paragraph 17. I say that to the best of my knowledge, information and belief that the defendant is in occupation and possession of the premises sought to be recovered herein, and I say that the defendant occupies the premises as a principal private dwelling. 18. By deed mortgage date 21st of April 2005, hereinafter called the mortgage, the defendant as registered owner or as the person entitled to be the registered owner charged the premises with the payment of the secured monies and assented to the registration of the mortgage as a burden on the folio as set out in paragraph 3 of the mortgage. I beg to refer to the true copy, and that's at Exhibit E. Paragraph 19. I say to the best of my knowledge and belief, no prior consent for the purpose of Section 3 of the Family Home Protection Act 1976 was required prior to giving of this security. Paragraph 16.1 of the mortgage provided that the mortgage could at any time transfer or assign all or any part of the mortgage, including the security created on the mortgage property, without notice to the borrower or any other person on such happening. All powers, rights, and discretion of society shall be exercisable by the transferee or assignee to the extent that they are so assigned and or transferred. Paragraph 16.2 of the mortgage states that the borrower irrevocably consents to all or any future transfer of all or any part of the benefit of this mortgage, including security hereby created on the mortgage property. Paragraph 22, judged by letter dated 9th of June 2014, the defendant was notified that legal ownership of the mortgage had transferred to the plaintiff, and all amounts owing by the defendant in respect of the mortgage were now owed to the plaintiff. As verted in paragraph 8, by letter dated 10th of June 2014, the defendant was notified by the plaintiff that as the owner of the mortgage and that the servicer would now issue service the mortgage on the plaintiff's behalf. I'd like to refer to a copy of the said letter from the Irish Bank Resolution Corporation Limited, on which marks the letter F by signing the inquiry swearing hereof. Paragraph 23. By loan offer dated 28th September 2004, the mortgagee agreed to provide the defendant with a term facility in the sum of €210,600 for a term of 30 years. Purchase the property set out in the schedule in the civil bill herein. Alternatively, to secure the said property, the said term loan facility was subject to interest at a fixed rate for a specified period of 3 years from the date of completion of the mortgage, and thereafter the variable rate specified, and was repaid in monthly installments. The said term loan facility was subject to terms and conditions detailed therein, and the mortgage conditions, and the plaintiff reserves the right to refer to the entire of the said loan offer and mortgage conditions for their full force and effect. Paragraph 54. The said loan offer is accepted by the defendant on or about the 11th of October 2004, and the said term loan facility was advanced to and drawn down by the defendant commencing on or about the 19th of April 2005. Under mortgage agreement number 1-400-190-4481, I beg to refer to a copy of the said loan agreement and acceptance upon which marks the letter G I have signed and inquired to thereof. By a further loan offer dated 4th of July 2006, the mortgagee agreed to provide the defendant with a term loan facility in the sum of €85,000 for a term of 27 years to purchase the property set out in the schedule in the civil bill herein. Alternatively, to secure on the said property, the said term loan facility was subject to variable rate specified and was repayable in monthly installments. The said term loan facility was subject to terms and conditions detailed therein, and the mortgage conditions, and the plaintiff reserves the right to refer to the entire of the said loan offer and mortgage conditions in full force of effect. The said further loan offer was accepted by the defendant on or about the 14th July 2006, and the said term loan facility was advanced to and drawn down by the defendant commencing on or about the 24th July 2006 on the mortgage agreement number 1-4-0-4-4-8-4. The beg to refer to the copy of the said loan agreement and acceptance upon which marked letter H outside being required to swearing thereof. Paragraph 7. The mortgage provides that all monies remaining unpaid and secured by the mortgage become immediately repayable if any payment or monthly or other periodic payment or payment of any other secured monies is unpaid or in arrears for a period of 1 month after the same shall have fallen due. In breach of said loan agreements, the mortgage, the defendant fails to pay the monthly installments as they fell due. In breach of the covenants contained in the aforesaid indenture of the mortgage date 21st April 2005, the defendant has since on or about 31st of January 2011 defaulted in payments of money due to plaintiff pursuant to provisions of the said indenture. As of the 19th of October 2017, there is due and owing to plaintiff the sum of £87,682.93, and for arrears of such payments, and the total sum now due and owing by the defendant and plaintiff herein amounts in the sum of €233,194. Beg to refer to copies of bank statements in respect to account number 14001904481, upon which marked the letter I as outlined prior to swearing hereof. In breach of the covenants contained in the aforesaid indenture of the mortgage, the defendant has since on or about the 31st of January 2011 defaulted in payment of money due to plaintiff pursuant to provisions of the said indenture. As of the 19th of October 2017, there are due and owing to plaintiff the sum of €39,874, and for arrears of such payments, and the total sum now due and owing by the plaintiff is €100,754.81. And the beg to refer to copies of bank statements in respect to account number 14001904484, upon which marked the letter J outside being prior to swearing hereof. By letter dated the 17th of November 2005, the plaintiff wrote to the defendant and demanded payment of all sums outstanding, including arrears in the 7 days of the date thereof. Despite the said letter, the defendant failed to pay the sum monies. The beg to refer to a copy of the said letter, upon which marked the letter K outside being prior to swearing hereof. By letter dated 22nd of August 2016, Mrs. Roland Daily German solicitors, upon instructions from the plaintiff, wrote to the defendant and demanded that the defendant deliver up possession of the property possessed within 7 days of the date thereof, in default of which proceeding seeking order for possession of the property was issued against the defendant without further notice to the defendant in writing or otherwise. Despite the said letter, the defendant failed to deliver up possession of the premises, and I beg to refer to a copy of the said letter, upon which marks the letter L outside the prior to swearing hereof. Paragraph 33. I am familiar with the CCMA 2013, which came into effect on the 1st of July 2013, being the most recent code of conduct on mortgage arrears issued by the Central Bank of Ireland. I say that CCMA 2013, issued by the Central Bank, sets out the manner in which regulated lenders must deal with borrowers who are either in arrears of the mortgage on their primary residence or are faced with the prospect of entering mortgage arrears. I say that the Central Bank published the first CCMA in 2009, and further revisions of the CCMA are made in February 2010 and January 2011 respectively. I am fully aware of the responsibilities and obligations under CCMA 2013 placed on regulated lenders when dealing with mortgage arrears and pre-arrears. I refer to Chapter 3 of the CCMA 2013, which sets out the requirements that lenders must comply with when dealing with borrowers in mortgage arrears or in pre-arrears situations. I said the framework of claims that correspond to the CCMA 2013 framework refers to paragraph 9 above, including mortgage arrears resolution process. I say that insofar as the period prior to the coming into force of the Credit Servicing Act on 8th of July 2015 is concerned, the plaintiff acted in a manner to correspond to the requirements set out in Chapter 3 of the CCMA 2013. I further say that insofar as the period since 8th of July 2015 is concerned, the plaintiff has not instructed the servicer to take or fail to take an action that would be in breach of such requirements. Provision 56 of CCMA 2013 provides that where a borrower is in mortgage arrears, the lender may only commence legal proceedings to repossession of the borrower's primary residence where either A, the lender has made every reasonable effort under the CCMA 2013 to agree an alternative arrangement with the borrower or his or her nominated representative, and B, part 1, the period referred to in provision 45G or provision 47D is applicable as required, and part 2, the borrower has been classified as not cooperating and the lender has issued the notification required in provision 29. 37, I say that the moratorium on commencing legal proceedings under provision 56 of the CCMA 2013 does not apply to these proceedings because the defendant has been classified as not cooperating. The notification required in provision 29 of CCMA 2013 has been issued to the defendant. I say the defendant was in arrears for a continuous period exceeding 3 months and had not meaningfully engaged or communicated with the plaintiff. I further say that as a result, the plaintiff has issued letters dated 26th February 2013 to the defendant to correspondence letter issued in correspondence to Section 8 of the CCMA 2013, warning the risk of being classified as not cooperating, as he failed to provide necessary financial information to enable the plaintiff to assess his current financial circumstances under the market process. I beg to first copy these letters marked with letter M, I sign my name prior to swearing thereof. I say there is no response forthcoming from the defendant. Plaintiff classified the defendant as not cooperating by letter dated the 7th April 2015, and I beg to first copies of the letters sent by plaintiff's defendant, correspondence letter sent to correspondence for the 29th season upon which marked the letter M, I sign my name prior to swearing thereof. Paragraph 40, I say the defendant appealed the decision of the plaintiff and appealed the word upheld the decision was passed by the bar as not cooperating by letter dated the 5th May 2015, and that's the O. Paragraph 41, I say the plaintiff's solicitor issued a letter dated the 14th of November 2016 to the defendant, and I beg to refer to copies of the letter sent by the plaintiff's defendant correspondence to the letter sent in accordance with Provision 58 CMA, and that's it, Exhibit P. I say we even advise the plaintiff's solicitor that as a result of the said default, the plaintiff is entitled to enter possession of said property without further reference, and I say we further advise by the solicitor to the plaintiff that there is no valid defence plaintiff is found herein, either law or equity or upon the merits of this case. I accordingly create a honourable court for an order in terms of out in civil guilt herein, and for such further order, including order as to costs on the 14's petition as proper. Paragraph 44, I say indeed that property is in principle private residence in the meaning of section 3 of the Land Statement in the Reform Act 2013, and mortgage was created prior to the 1st of December 2009. Most recent updated figures just as of yesterday on mortgage account number 14001904481. The outstanding balance is €274,266.61, of which €168,702.29 for arrears.
168,702
€1,702.29. The net monthly installments on that account judge should be €1,083.59. And regarding the last three payments on the account judge, they were this account migration to Pepper Finance, that's pre-2014 judge. On mortgage account number 14001904484, the outstanding balance as of yesterday is €119,677.31, of which €76,297.58 are arrears. And the net monthly installments that account judge should be €478.25. And similarly, judge, the last three repayments in that account were through the migration to Pepper, so pre-2014.
You proved your service, the respondent is here, and there's no outstanding proofs.
No outstanding proofs, judge. We mentioned proofs on the last two occasions also, judge.
Very good. Now, what do you say? There appears to be a large amount of money outstanding where we were given a more...
I have money here.
Just a moment.
I have money here, rory-brian. Now, I just wanted, before we continue, Eugene, before we continue, we are here.
Excuse me, I'm the judge here. You address me. You do not address anyone else in this court.
I will address you as a judge under law. Okay? You've just acknowledged in my heart, you've acknowledged Roman civil procedure. There's no okay. We will have no more shame.
rory-brian, could you make sense, please? You seem to be talking...
Are we here? Okay, what will make some sense? I will ask sensible questions. I will ask honest, factual, setting questions. Who, within this arena, have honourably, honestly, and in all sincerity, point out the person who owes said money debt?
Continue. Mr. O'Mahony will have an opportunity then to
Second time.
your question.
Who, within this arena, can honourably, honestly, and with all sincerity point out that person who owes said money debt? I'm going to speak to you one more time when I ask this question.
No, just a second. Your
One more time.
opportunity now is to...
One more time. Acquiescence. Who within this arena
For the record,
can honestly
pointing to rory-brian.
and in all sincerity point out the person who owes money debt? Are you putting personage on I, rory-brian?
Correct.
Let no man or woman put personage upon I. A man, rory-brian, for that is a crime of bondage, and a furthermore is an unlawful conversion without consent. Did we witness this in a court of law today? Is it true? Is it true, Eugene?
Excuse me,
Is it
I
true?
am the judge here. You speak to me, you don't
Is it
speak
true,
to
Alice?
anybody else.
Is it true?
What's true?
Let no man or woman, you understand? Put personages, you understand? Personas, you understand? Upon I,
Yeah.
you understand? I am rory-brian.
Yes.
For to put personage on I is a crime. Is that true? Is it true an unlawful conversion without consent is unlawful?
I'm not dealing with that. I don't agree with your last statement. And
Excuse
that
me,
is my
hold
point.
on here. In a court of record, in a constitutional Irish court of record, this man, there's a member of the Garda Síochána here in the court, under Irish law. I'm going to ask you to
You
witness
are
the crime.
not going to ask.
I'm going to direct you. I'm going to require you under law, or you are required. And you must, and you will. All men and states must be referred. We the people of éiRe do hereby adopt, enact, and give ourselves this constitution. I'm going to ask one final time, and I'm going to make this very clear. I'm going to make this very clear. In front of all Garda Síochána, the judiciary, and Irish law. Let no man or woman or person disorderly upon I, a man or rory-brian. For that, witness from Garda Síochána, for that is a crime of bondage, and furthermore is an unlawful conversion without consent. Witness Eugene, Alice, from Garda Síochána, members of the public, people, Irish nationals in the territory of éiRe have witnessed a crime. Shame. I require you, under law, Garda Síochána, I'm reporting the crime.
Or outside.
Thank you. Thank you for acknowledging the crime.
I didn't say no.
Yes, you did.
Right, anything else?
Anything else? Are you going to honour? On my property.
Yes.
On my property.
37 months.
My property, Irish law, éiRe, territory, been established, it's been acknowledged, you've been accepted. We're here, you're in it. Are you going to honour? I, rory-brian, my family, my territory, my life, my property, under Irish law. Alice, are you going to honour this?
You will be honoured.
Are you going to honour law?
You're not going to.
The question is, I want an answer. Why would I listen? I want an answer.
Yeah, what?
Please answer the question. Is it true you're going to honour Irish law?
I'm going to honour Irish.
Go to name, Marcus.
the Irishman in here.
Nothing right in
Very
there.
good, thank you. I heard the case, I found the facts phone and the proofs are in order. I granted an order for possession of the premises
Shame.
of media appearances.
You are now committing a crime under Irish law.
She can hit to a kid's crime.
God's shame on you people who sold out.
All that and
You were standing wearing
as Paul shown,
Blue crown,
and Rory in the county.
black morning clothes under oath of the premises of éiRe. You will not leave this court. You will not break the law inside of my constitutional court of record. You will go down in shame. You will be done under Article 34.1.
Are you looking for an order for sale? And I've granted an order for the sale of the said premises and the distribution.
You will do no such thing. I object. Eugene, I am speaking to you as the trustee. You are administrator. You are the administrator. You are the trustee. I am the beneficiary. You are the debtor. You have just shamed law.
I'm not giving you.
You are not leaving this court. You are not making. You will not. I am an Irish national. You cannot. You cannot.
You have 10 days to appeal.
You cannot. You cannot leave this. Eugene, you are not leaving this court. Eugene, this is my court. You will sit down. You will not leave this court. You will not. You will not leave this court. You will not leave Irish law. Does any man and woman within this arena, in the territory of éiRe, want to break Irish law? No, we're here in Irish law. Thank you. Eugene, you are required to continue on with business under Irish law. You are sitting under the Irish sovereign seal of éiRe, the territory. You will not leave my court. You will not leave Irish law. Eugene, you need to accept this court here today. Silence in the court, please. Silence in the court. We're still in court. We have members of the Irish Sheik coming. I want your protection, please. Thank you. Who are you?
I'm sorry.
Identify yourself. Your name, please.
Okay, folks, the court is finished. No more hearings today, so please leave the courtroom. My board building. Thank you.
How dare you? Eugene.
2 p.m. The issue to earlier, the court 2 p.m. not 4. Thank you.
Eugene, are you here under Irish law, constitutional court of record? Here, I require you to stand in Irish law. I want to report, fine.
Do that fair session. Outside.
You outside, what's your name?
Mickey. You may speak.
rory-brian. Okay, thank you.
Thank you.
Thank you, ladies and gentlemen. I'm here for... We've just been acknowledged, the crime has been acknowledged, we now use a barge upon it to assist us, the people.
Yeah.
Thank you. Please acknowledge and respect the territory that gentleman is in, and we will leave. We will be our stand castle or barge upon it. Let's talk to this. Thank you.
Going to hardcore, boys. We're going to hardcore. This has been appealed and we'll go to hardcore. We bring this to the Supreme Court and we will win.
Integrity and everything. No rent whatsoever.
please, I'll meet you all outside. Thank you. I'm glad it was good. Not even perfect safety. I'm not saying, I'm saying, I'm here, these people are protected here. These people in uniform are protecting us here. I want you to know that we're all together. Everybody that's in this building is being together, merged all now. Okay, so we're all together. Everybody around here is